calling 2023 CR 0881, State of Texas versus Amanda Villegas. Can I have parties announced for the record for the state?
Jason Garrett for the state, Your Honor.
Who's the attorney for Amanda Villegas?
Josie Richardson for the defendant, Your Honor. We have a substitute counsel for the state.
All right, thanks. For the state.
Debbie Cruz on behalf of the state, Your Honor.
And are you Ms. Villegas? Counsel, have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Villegas, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Ms. Villegas, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of driving while intoxicated with the child under 15? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
That's true, Judge.
Ms. Villegas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishments be assessed at 2 years in the state jail facility. There's a $1,500 fine. State recommends community supervision, the VIP, and ignition interlock. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have, did you understand by, I'm seeing something else that's popping on my screen. Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation of 150 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Yes.
State any evidence?
The state introduces State Exhibit 1 and all of its attachments.
No objection, Your Honor, but she did want to plead no contest.
All right, are you pleading guilty or no contest? I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront the state calling the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand? Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept the evidence, States Exhibits 1 and attachments, and review the same. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. We respectfully request that the entire fine be probated.
All right. Ms. Villegas, is Child Protective Services involved?
They have another loss.
So where's your child?
She's with me. She's with me.
All right, so you want to explain to the court why you were driving with an infant asleep in a baby seat. And according to this, you had 2 open containers and a center console cup holder, a 24-ounce Bud Light, 24-ounce of twisted tea, and that your speech was slurred, and they had odor intoxicants coming from your breath, and your eyes are red and glossy. Where are you coming from?
My family's house, they were down the street from my house, trying to get home.
All right, you're gonna have to speak up. Where were you coming from?
Family's house, we were drinking at family's house.
So your family allowed you to leave after you had been drinking with an infant in a car seat. Nobody said, hey, you're intoxicated, you should not be driving with an infant in a car seat. Okay, you're whispering.
No.
So how have you been addressing your alcohol issues?
They don't believe about the alcohol issues.
Again, my statistics professor would be very upset with me, but usually people who get pulled over and plea to driving while intoxicated, that's just the first time they got caught driving while intoxicated. I don't know anybody who is taking an infant and driving with an infant while you're intoxicated and saying, I don't have a problem. Obviously you do.
Pause right there. Driving while intoxicated with a child under 15 in Texas is not a simple DWI. This is a state jail felony that means up to 2 years behind bars. Notice how the judge slowly explains every right. This is not just formality, this is protection. For the record, once she says guilty, there is no easy rewind button. Question for you: do most defendants truly grasp what they are giving up in this moment?
And obviously your family has a problem if they were so intoxicated that nobody told you you should not be driving, one, at all, and doubly when you have an infant in the vehicle. So when's the last time you had alcohol? And you need to be honest with the court.
I haven't been drinking ever since then.
All right, everyone needs to whisper. So when's the last time that you drank alcohol?
Since I got caught with alcohol.
All right, I find that unbelievable. Are you in any type of program? All right. Do you have any criminal history other than this?
Misdemeanors.
Misdemeanors for what?
When I was like 17.
No. What's the charge?
Possession of marijuana and failure to ID.
All right. And if you're drug tested today, what are the results going to be? All right, let's do a UA. And we'll come back and take care of the rest of the hearing after she submits her UA.
Okay, how long should that be?
Oh, it'll be fairly quick.
Okay. I'll just make a short exit for 5 minutes. Will that be okay?
Yes, 5 minutes, but we have a jury coming in at 11:30, so you need to be back before 11:15.
Thank you, Judge.
Court is going back on record in 2023 CR 0881, State of Texas versus Amanda Villegas. All right, Mr. Richardson, I need you over there. All right, this is what the court is going to do. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 2 years. There's a $1,500 fine that will be probated.
And just like that, the court finds sufficient evidence and enters a guilty finding. No dramatic witnesses, no emotional testimony, just paperwork and stipulations. This is how plea hearings move fast, but do not confuse speed with softness. The real tension always shows up during sentencing.
There's to be the VIP, ignition interlock, DWI education course, 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do the COVID vaccination, but if you do, 40 of those hours will be waived. I'm going to want parenting classes. Once those completed, the remaining of the community service hours will be waived. There's to be ignition interlock for a full term. Counsel, the court will reconsider once she has been on probation for a significant amount of time. I'm going to want 90 meetings in 90 days. Probation, do a TAP evaluation. If the TAP evaluation recommends inpatient treatment, we're going to start with supportive outpatient treatment. I'm going to want field visits 1 time per month, and probation, that field visit can count as her reporting. There's to be regular reporting by Zoom or in person. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. All right, probation, is there anything else? Thank you. And regular UAs. Anything else, probation?
No.
Ms. Villegas, is there anything else you need from the court? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Did you hear that shift? The judge is no longer just processing paperwork. Now she is testing credibility. When someone says, I do not have a problem while holding a DWI with a child case, it raises red flags. Courts are looking for accountability, not denial. Be honest. Does that answer sound convincing to you?
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. We can go off the record. Here's the thing, Ms. Villegas. Whenever you get behind the wheel and you've been drinking, what usually ends up happening, if there's an accident, the person who's driving intoxicated, it's rare that they get injured. Usually it's somebody else gets killed or somebody else gets injured. In this case, it could have been somebody else or it could have been your child. If you love your child, then you should not be driving after having taken a drink. And while you're on probation, you're not allowed to drink alcohol at all. That means if you go over to your family's house and you all are having a barbecue or whatever, you're not allowed to drink alcohol on probation, period. You understand? All right, good luck to you. Probation will go over conditions. All right, court is calling 2019 CR 10914, State of Texas versus Maricela Beatriz Cuellar. Would our parties approach and announce for the record?
Daniel Escobar for the State of Texas.
Eddie Garcia from Ms. Cuellar.
And are you Ms. Cuellar?
Yes.
All right, Ms. Cuellar, I'm going to show you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Maricela Beatriz Cuellar who was placed on deferred adjudication in 2019 CR 10914 for the offense of evading arrest detention with a vehicle on January 10th, 2020 for a term of 3 years? Is that you?
Yes.
All right, state.
Violated condition number 2 on or about 20th day of October 2020 in Bexar County, Texas. The defendant, Maricela Beatriz Cuellar, did then and there fail to submit to drug testing as directed by the court officer or supervision officer and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine?
Speak up so she can hear what.
All right, so everybody to my right, y'all gonna need to be quiet and wait till the court is off the record. Sorry. All right, knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there an agreement?
Yes, Your Honor, it's to adjudicate guilt and then alternative for bi-weekly or includes bi-weekly UAs for 60 days on IVR call line and monthly UAs thereafter.
Is that the agreement?
It is, Your Honor.
All right, Ms. Cuellar, when you drug tested today, what are the results gonna be?
Negative.
Okay, we're gonna do a drug test today, and then
You did one yesterday, Judge, at the direction of probation. I don't know if the results
Probation?
are back.
are the results back for her drug test from yesterday?
I'm good right now. I'm clean.
All right, okay, let's do a drug test.
Okay.
Thank you. All right, so we'll do a drug test, then I'll make a ruling on this.
Okay, Judge, we'll stand by.
All right, thank you.
Excuse me.
We're back on the record on 2019 CR 10914, State of Texas versus Maricela Cuellar. All right, Ms. Cuellar, I have received the results back, And I'm so happy that you were negative. I'm glad that you're doing what you need to do, okay? So let me ask you, is there a reason why you haven't been submitting? What's going on in your life?
It was just a lot, and I know I don't want to explain it, and it sounds like an excuse.
No. I just want to find out so we won't be here again.
Back when I first got put on probation, that's kind of like when COVID started, and my mom did get sick.
Mhm.
So I was working 2 jobs at the time. I was working at Santa Rosa, and I was working at Wendy's.
Okay.
So I was just constantly on the go, and I wasn't really thinking so much of myself. I was just, trying to make ends meet for my mom and my stepdad, because I was helping my stepdad at the time pay the rent. I was paying my mom's car, and I just got off track, I guess you could say. And now that I have my son, I realized the opportunity that I had, which was deferred probation, was a big opportunity that I could have, if I would have just submitted my drug test, that, it would have been a good thing for me. But now I'm just trying to do better for my kid, for my family. I'm taking this as a life lesson.
Okay. So are you employed now?
Yes, I am. I
And
work
what do you
at
do?
Chick-fil-A on Alamo Ranch.
Chick-fil-A, they do put sugar in their recipe, don't they?
Honestly, I have no idea.
All right, so they've told her not to ask. I think they put sugar in there or something,
I think it tastes good.
Judge, it's an ironclad NDA.
Yes.
It's top secret.
But if you go online, they will tell you what exactly they do. So I'm partial to their lemonade, but that's just me. All right. What are your hours working there?
For now, I'm doing like 5 to close, which is like 5 to 10 or 11 the latest.
Oh, so 5 p.m. to close.
Yes.
All
I
right.
was supposed to be alternating with my mom, because my mom works in the mornings there. We work at the same location. And she was supposed to be my childcare, but she broke her foot. So now it's me and my boyfriend that are alternating schedules. So he'll work Monday through Wednesday, and I'll work Thursday through Saturday.
All right. And so how old is your child?
It's 7 months today.
Oh, okay. So you trust your boyfriend with your baby?
Oh yes, he's a great father. He's
He's the biological father?
he's
Okay.
he's a great father. He helps me a lot. When I was in custody, he was amazing. He would go to my mom's every day, have my mom see the baby. He took care of the baby, but he didn't really have help.
Boy or girl?
He's a boy.
All right. What's his name?
Kenji.
Okay, Kenji. All right, that's a great name. That's a cool name. And court reporter wants to know how to spell that.
Kenji.
Okay. All right. So this is what the court is going to do. Court is going to deny the motion, alter the main conditions to include probation. Should we do UA hotline for her, or what do you want to do? I'm not going to find her guilty.
Well, Your Honor, her case expired January 9th of 2023.
Oh, so she's done. Yeah, I'm denying the motion. You're done.
Happy birthday to your son.
Yes. All right, we can go off the record. So here's the thing. You've done great. You're on the path. You've been testing negative. You need to make sure you do that because your son is depending on you.
Oh yes, he's like everything.
Okay. All right. Good luck. Happy Valentine's Day.
Thank you so much.
All right. Bye-bye. All right. The court is calling 2019 CR 6812, State of Texas versus Joshua Tremaine Carroll. Can I have parties announced for the record for the state,
Jason Garrahan, Your Honor.
for the defense?
Charles Bunk for Mr. Carroll.
And are you Mr. Carroll?
Yeah.
All right. So you entered a plea to paragraph B on September 28, 2022. The court found there was sufficient evidence to find you guilty. The court found you guilty. There were no applications. So that was in September of 2022. So why are we just now doing this in February of 2023?
You had allowed him some time to get his affairs in order. He had an unfortunate event which caused him to miss his court date. So they picked him up rather than come to you when he got picked up and ask you to consider a bond and getting him out. I left.
This is a power move. Immediate UA drug test. Why does that matter? Because credibility in court is everything. If someone claims sobriety but tests positive, the judge trust evaporates instantly, and without trust, probation becomes much harder to secure. One test can shape the entire outcome.
We left him in there on purpose to pay his penance, and we're asking you to follow the plea bargain if you would.
All right, according to the plea bargain agreement, punishments be assessed at 2 years in the prison. There's a $500 fine, and it says that both parties agree that if he didn't show up for sentencing, he would be subject to the full range of punishment. So, State, are you still proceeding with the plea bargain agreement?
Your Honor, in light of him not showing up, I believe the full range, as it says in the agreement, at this point, we'll defer to the court for the reasoning behind that he didn't show up and if it was a valid reason.
Right.
You want
to call your client as a witness to explain?
Yes.
Could you raise your right hand for me?
Raise your hand.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Ma'am.
You can lower your hand, state your name for the record. State your name for the record.
Mr. Carroll,
All right, why didn't you show up for court?
because I have some problems.
We all have problems, but you're not telling me what your problems were.
Well, first of all, my daughter had her baby, but I came up with I was sick soon, so my corona.
Everybody used coronavirus as an excuse, but did you provide any medical documentation that you had that?
Yeah, I do. I have that.
No. Did you provide any medical documentation to the court that you were ill?
I think I did. I should have. Do you have any?
I do not. Not for the date you're addressing, Judge.
Yes. So you did not, because if you would have, I would have that, and I don't have it.
So you don't have any paperwork at all?
I don't have anything to show that you were ill, and that's the reason why you didn't show up for your sentencing. I do have that I was lenient with you to allow you to get your affairs in order and to come back on a different date for sentencing. That's what I have. So why shouldn't I sentence you to beyond the 2 years? Because that's your agreement. Your agreement is if you don't show up for sentencing, you are subject to the full range of punishment.
This is the moment the temperature changes when a plea agreement says you are subject to the full range of punishment. It is not decorative language, it is real. 20 years is not a scare tactic, it is legally available. Missing court is one of the fastest ways to lose judicial goodwill. Do you think the judge should stick strictly to the agreement or show mercy here?
So my question to you is, why shouldn't I sentence you to 20 years?
Say that again.
Your agreement was that if you did not show up for your sentencing date, that your range of punishment will be up to 20 years in prison. You did not show up. So the question is, why shouldn't I send you to prison for 20 years?
I most definitely didn't understand that one.
No, you did, because it's a part of your plea bargaining agreement. And what I can tell you, and I'm sure your counsel will tell you this, and even though this is a new prosecutor to this court, I go over the plea bargain agreement in great detail and ask on the record, do you understand that to be the plea bargain agreement? And usually, well, not usually, every time I ask the defendant first, do you understand that to be the plea bargain agreement? And they will say yes. Then I will either ask the state of the defense attorney, is that the plea bargain agreement? And I can tell you that you were aware that you were subject to the entire range of punishment. So we're back to this. Why shouldn't I sentence you to 20 years? Because that was your bargain, that if you didn't show up for court, that you will be subject to the full range of punishment. And I remember all of the people who say, give me some extra time and I will show up.
What was going on with your daughter today?
Yeah, I mean, she had a baby next month or whatever, you know what I mean? But I don't think.
What do you mean she has her baby next month? You told me she already had the baby.
No. She went in the hospital. She was sick. I thought that she wasn't gonna even, that she was gonna lose the baby or whatever, you know what I mean?
And when did this happen?
Like last month.
All right, so that happened last month, so that would have been January. So that still doesn't explain why you didn't show up for your sentencing on November. You were set for sentencing on November 3rd. Here's the thing. Sometimes people don't have an excuse. Sometimes it's like, I made a bad decision. I was enjoying my free life out here and I just didn't show up. So I'm trying to figure out, is that your case or is there something else that was going on in your life? Because you're looking at 20 years in prison.
That he doesn't have an excuse that we want to offer at this time. He does. I agree with the court. You did admonish him. He understood that. I'm concerned. I mean, as we stand here today, he's not near as cognizant of I've dealt with as he's been in the past. I'm somewhat concerned about that, but he's not a man of means. When that November date came, his phone was cut off. We were not able to locate him. He didn't. I know I spoke to him after that when his daughter was sick, but we'd ask you not to sentence him to 20 years. We don't think that's, we hope that that's not what the court decides to do, but if the court decides, we ask the court to follow the plea bargain and perhaps give him 3 years. As an indicator that the court takes this seriously. And
all right, state.
In lieu of the explanation, the judge, the state, with previous negotiations that they have in our file, we believe the appropriate sentence will be 5 years. 2 years.
All right, this is what the court is going to do. The court will sentence you to 4 years in the prison, give you credit for any time served, take in consideration 2021 CR 2207, 2021 CR 1465, 2021 CR 2771. The court will give you credit for any time served. There's a $500 fine. Time and money will run concurrent. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? We can go off the record. Mr. Carroll, I always, when attorneys say, can you give my client some extra time to report? Sometimes I do, sometimes I don't. But I take it very seriously when I give someone time to report, because when you think about it, somebody's saying, all right, I'm going to show up and I'm going to take my prison sentence. You didn't show up. And that's a problem. And if there would have been a good explanation, things may have turned out differently.
I don't even remember the
All right, so you can have him have a seat. They're supposed to impact. There's not?
No,
All right, thank you.
Judge, sorry. We're just going to go ahead and surpass that because
Court is calling 2022 CR 2009, State of Texas versus Jose Guadalupe Garcia. Could I have parties announced for the record for the state?
Jason, do you have from the state, Your Honor?
For the
That's
defense?
Soldansky for Mr. Garcia.
Are you Jose Garcia?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor, I have.
Court will find that the state is in compliance with discovery. Mr. Garcia, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
And for all parties, are we proceeding on this case only? Are we proceeding on this case only?
Oh, yes, ma'am. The others will be encompassed in the plea.
All right, thank you. Mr. Garcia, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with felony in possession of a firearm? Off the record for a moment. Mr. Brooks, are you enabled? If you can move down, you and your client move down that way. Thank you. No problem. All right, did you understand you're charged with felon in possession of a firearm? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today did you understand that today by entering in this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court would grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain agreement, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 8 years in the prison. There's a $1,500 fine. The state is remaining silent on your application. They're taking in consideration 2023 CR 0705, 0706, 2022 CR 3151, and County Court Cause number 688228. There's to be restitution, if any, to Hector Calderon in 2023 CR 0705. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, ma'am.
State?
It is, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Okay. No contest, ma'am.
State any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
Your Honor, I've reviewed those with my client. We have no objection.
All right, Mr. Garcia, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We will come back on April 6th. At that time, I'll make a decision on your application. My decision will be based upon any information I received and any other evidence that's presented. Is there a need for a TAP evaluation or no?
No, ma'am.
All right. So probation, just PSI report, no TAP.
Your Honor, Mr. Garcia is in custody. We were here on the 24th or 27th. I don't remember which day it was. We broke for lunch. He left. His wife went into labor. They had a little baby girl. I got in touch with his mother, told him that if he didn't come back, he'd have a warrant. Well, he didn't get back. So the next day or 2 days later, he turned himself into the police for this warrant. We're asking that you reinstate his bond. As far as excuses go, it's pretty good.
All right. So I'll need some actual documentation.
Baby?
Well, no, I mean, not the baby, but some documentation about, the fact that she was at the hospital that day.
Yes, ma'am. Well,
right.
She was here. And then she went to labor here, and then they went over to the hospital and she had.
All right. So if you'll bring documentation of that
ma'am.
and share it with the state, and then I'll
Okay.
consider it.
Right. Thank you.
All right. Thank you.
For years, not the maximum, not the original bargain, somewhere in the middle. This is what judicial discretion looks like in action. Courtrooms are not just about law, they